Welcome to this presentation regarding legal letter writing. Really, the secret to legal letter writing is that an effective legal letter is an effective letter. It really doesn't have components that are different than an effective business letter. So if at some point in your career you have been responsible for writing business letters, the same guidance that you received at that time is the guidance that's going to apply here. Probably the only difference is going to be that a legal letter is going to be perhaps a little bit more formal, and some of the finer points may be more important to focus on in terms of making sure that you're using the right punctuation and things along those lines. This course is not a course that we're focusing as much upon the format. I'm going to introduce you to some effective formatting tools for legal letter writing, but that's really not what this class is about. We have another class in the program called Advanced Legal Documents Preparation. That is LGLA 2333. It is an elective for Associate of Applied Science students, and it is a required course for certificate students. We highly recommend it even if you are an AAS student, because as part of that course, each student prepares many documents that will be ready for a portfolio, so that when he or she goes to a job interview and is asked to show some documents that he or she has performed, he or she will have some beautiful legal documents that any law firm would look at and say, that's exactly what we want our documents to look like. The presentation style of a legal document is very important, and so that I don't want to diminish that when I talk about this course, but just really want to say that we focus on that in a different course. I'm going to share some of that in this presentation, but I'm going to kind of do a bit of a light touch. If you don't happen to follow all these guidelines in this class, you won't see as dramatic a deduction as you would have if you were taking the Advanced Legal Documents Preparation class. If you've taken the Advanced Legal Documents Preparation class, then I know that your documents are going to be, not only the content is going to be awesome, but the physical preparation is going to be beautiful. And so I just want to encourage you to apply those tools if you've learned them in the other course. And if you haven't learned them, see this as an opportunity to grow those skills. Okay, so let's get started. Okay, let's first of all talk about when we use letters. I think it's important whenever we have a conversation about written communication to think about when is it effective to send a letter or send an email or send a text or whatever it is versus doing some other type of communication, perhaps a telephone call or perhaps a face-to-face meeting. Many times this will be something you'll want to discuss with your supervising attorney, but here are some things to think about. First of all, a letter is a more secure means of communication than email, so many of the concerns we talked about when we're talking about email aren't as kind of front and center as you would have with a letter. It's pretty unusual that you accidentally mail a letter to the wrong person, and certainly a letter cannot be forwarded with the same ease that an email can be forwarded. And it can't be intercepted nearly as easily. So for those reasons, it is quite a bit more secure than an email. But it does have some opportunities associated with it. For one thing, when you send a letter, the subtleties of intonation and body language and the back and forth of a communication that is done by voice or by face-to-face presence is lost. And so there's a significantly greater chance for there to be miscommunication, for the tone to be misunderstood, or for a subtle aspect of the communication to be lost. Plus, many individuals are not careful letter readers, and they might skim it, or that just might not be their preferred way of getting information. And so there is a chance, especially with non-legal professionals, that they won't read the letter as carefully as they ought to, and therefore they don't get the information that they need. If you're having a telephone conversation or a face-to-face meeting, you're able to kind of correct for that by asking the person to repeat the information, or by asking questions about the information to confirm that they've understood it. So there are some disadvantages to letter writing, but there are also some important advantages. One advantage, and this is not trivial by any means, is that you have a document that confirms that you actually communicated the information. We would all like to live in a world where we and our clients always are in perfect agreement and are lockstep. And that happens sometimes, certainly. But unfortunately, um, sometimes clients and attorneys can have a more complicated relationship. And even when the relationship appears great and is great, there's always the potential that in the future it may not be so great. And so one needs to be aware of that possibility when you are considering communication. If you have a telephone communication or face-to-face meeting, what was said and what was not said becomes a matter perhaps of dispute. The client can say, well, you never told me that, or you said it to me this way, or you gave me this information, when in fact it's your recollection you gave different information. If you have it in a letter format, though, it really can't be any source of dispute about what was said in the letter. And so it can be a powerful way to document the conversation. This works not just with clients, but also with opposing counsel, with the court, with other parties. You have a record of what was said. It's one of the reasons why many times people will have a conversation and then document the conversation afterwards with a letter, and maybe a brief letter, but some letter memorializing the conversation. So there are lots of things to think about when you're writing a letter, lots of things to consider whether the letter is the right way to communicate or not. And as I say, it's going to be a discussion that you have with the attorney to figure out what makes sense in a particular situation and what the attorney's general preferences are. So be sure to have those conversations on a pretty regular basis, especially when you're starting out in employment, so you're not sending too few letters or perhaps not sending too many letters. So let's talk about the format of a legal correspondence. The first thing, of course, is the letterhead. The letterhead only is used on the first page, and it is literally at the top of the letter. That's why we call it the letterhead, obviously. We want to use that again just for the first page. Most law firms are going to have a stationery that's printed with a letterhead on it. A startup law firm, though, might just have a template on their software, or word processing program that populates their documents. It's a less expensive path. It may be a path that's used when a law firm changes locations. There may be some period of time where they don't yet have the stationery ready, or they may be in some kind of a temporary location that they have, or using temporary type letterhead. So sometimes it may not be a printed paper, but for the most part it will. And you'll want to use that every time, but you'll only want to use that on the first page of the letter. Then, of course, there's some other information you have to have in the letter. You have to have the date. The date isn't the date that you wrote the letter, but it's the date that you mailed the letter. You may, for example, be working on the letter on Friday, but you've got to confirm one more fact, or maybe you want the attorney to look it over before you send it out. And so it doesn't actually get into the mail until Monday morning. Well, you will need to make sure that the date on the letter is Monday morning. So the date that actually the letter leaves the custody of the law firm and is in the custody of whatever mail service you're using is the date that you ought to use for that letter. Then you'll want to cover the mode of delivery. If you are sending your letter any way other than U.S. mail first class, you need to specify the mode of delivery. So if you're sending it UPS overnight, or you're sending it certified mail, return receipt requested, or something like that, those are probably two pretty common ones. Obviously, FedEx is also a good service. But if you're sending it those means, then you'll want to specify that in your letter. Many times people will put tracking numbers actually on the letter to have a record of that in a handy location. That's optional, but you'll want to specify. You can actually specify even if you send it U.S. mail, but you don't have to. That's kind of the default setting. Anything else, though, needs to be specified. Another way that sometimes letters are sent is by courier or by facsimile, and those ought to be specified as well. Then you'll have the inside address block. This is the address of the person or the business to whom you are sending the letter. It will be below the date and below the method of delivery. Sometimes you'll be sending a letter to more than one person, and if they are at different addresses, then you will list more than one inside address. You will want to use obviously the same address that you're using on the outside of the envelope. You may want to make it look a little bit nicer. The post office, if you're sending it by U.S. mail, the post office likes to have an address look a certain way. It's not the most attractive way, but it's a method that allows their readers to read the address easily, and so it creates less of a chance of it being misrouted or lost. And so it makes sense to do the outside envelope that way, but many people prefer to change the inside address so it's a more attractive, a more professional look. And so as you consider that, you may want to consider that possibility that even though the address information will be the same, the actual formatting that you do will be a little bit more professional on the inside address. The next line that you'll have is your reference line. Many times this is called a ray line. A couple of stories about how it got its name. One is some people think that the ray line means that it's the reference line, so it's an abbreviation of the word reference. Some people think the ray line refers to the Latin word res, which means thing. So it's the thing about the letter, the subject of the letter. Some people call the ray line the subject line. All of those are okay names for it. It doesn't really matter what you call it, but you do want to have that. Hard for me to imagine any letter other than possibly a thank you note that's not going to have a ray line associated with it. The reference line does a lot of very important things for both you, your file room, and the person who's receiving the letter. It is a gift that keeps on giving. Do you have to have it? No, you don't have to, but I think you're going to find that more often than not it causes you more hassle not to have it than if you do have it. So I encourage you to put it in your letters, and definitely for this course it's an expectation that you'll have a ray line in any correspondence that we prepare. So what do you want in a ray line? Well, the first thing to keep in mind is while I use the term line, singular, I don't mean to limit you and say that you can only have one line. It's very common to have even 3 or 4 lines as part of your ray line. That's perfectly appropriate and can be very, very helpful. Things that you're typically going to put is you're going to put the matter information. So for example, let's say it's about a lawsuit and the style of the case is Smith v. Green. Well, you're going to put Smith v. Green as one of your ray lines. If it's already been filed in court, you're probably going to include the case number. You're likely going to include your file number within your law firm. If you happen to know the file number that the other side, if you're sending this letter to opposing counsel, the file number that they are using, maybe you've seen it in previous correspondence, as a professional courtesy, it's certainly nice to include that on the letter that you send to them so that it makes them easier to find the right file and to file it. But as a minimum, you're going to want to list your the name of the file in some mechanism so that, and let me just explain why you want to do that. First of all, it's going to help you, and if it's not you, someone in your file room file that letter correctly. It's going to make their job quicker for them to do, and they're going to have a smaller chance of misfiling the document. That little effort on your part is going to save time, because if they have to look up the matter and read the letter to figure out what's going on, that's slowing them down, and putting a ray line in it just takes a few seconds. So it's a kindness to your file room, and again, it's a kindness to you, because what if they misfile the letter? It's a kindness to opposing counsel or whomever you're sending a letter to. You may think, well, sometimes I don't want to be kind to those folks. Well, you're right. Maybe you do have an intense relationship with them, and so I suppose you could leave it off. But if you're sending them a letter, you presumably want them to do something with the letter. And by putting the reference line in, you're helping them know what this case is about. It helps them know how to prioritize the matter. It gives them useful information. And most of your correspondence isn't going to be heated. In fact, really the heated letters are probably going to be from an attorney to another attorney. The odds of you being in the mix of sending heated correspondence is pretty small. So hopefully your correspondence is going to be more in the helpful, cooperative mode, whether it be with a client or an expert witness or opposing counsel. And so you want to make a good impression upon them, make them interested in helping you. And one way to do that is to make their lives easier and their file clerk's life easier by having a ray line on it. So that's why you include client information. In addition to client information, though, you'll want to include something about the particular matter. Very likely you're not going to be corresponding in your letter about the entire case. You're focusing on one particular aspect of the case. And so by narrowing it down, you're giving that reader more information. You're also giving yourself more information. So if you have to go back through the file and find that letter, having a ray line that helps you know what this particular letter is about is going to save you time. It's just a professional courtesy, and it's a professional expectation. If a person receives a letter without a good ray line, it kind of doesn't reflect the best upon the letter writer. So you want to include the specific subject of the matter, simply stated, and you want to include client identification information, matter identification information. On the line below the reference line, you want to have a salutation. This is a greeting. And in everyday personal correspondence, we use lots of different, or many of us use lots of different greetings. We might say hi, we might say other things, but for a legal business letter, there's a very clear protocol, and in a way that makes it easier. Knowing exactly what has to be said and the way to say it means that you don't have to worry about it. You can go on automatic pilot when you do the salutation. So I'll show you the form in a second how that ought to look. Then we have a section for the header and the footer. Of course, the header is at the very top of the letter. And on the first page, of course, the only header we're going to have is that letterhead. On subsequent pages of the letter, we'll want to identify that it is the second page or the third page or whatever the page number of the letter is. And we'd also want to identify not just the number of the page, but also that it is in fact that same letter. It's not unusual for pages of a letter to get separated once they arrive at their destination. And so if you say, page 2 of 4 pages, and then you say letter from Mary Green to Bob Smith, and then the date of the letter, it makes it much easier for that recipient to keep all those pages together. That's kind of a courtesy. So that might be kind of a header. I usually actually don't put that in a header. I actually type that out of my document, but you certainly can consider putting it in a header. But let's talk about the footer. Many letters you're going to want to have a footer. If you're corresponding with your client, or if you're corresponding with somebody within that circle of trust within that particular matter, for example, an expert witness or something like that, you're very likely going to want to have some kind of attorney-client statement in it. That way you are putting yourself in the best position to preserve that privilege. We'll talk in the ethics section about how that isn't magic pixie dust. It doesn't turn a non-privileged communication into a privileged communication, but it is one of the indicia that the court would look for in determining whether this is a privileged communication or not. So it can be helpful for you. Now, it's probably not a good idea to put that footer on every single letter that you send out, although you're going to want to defer to your attorney to see exactly what his or her preferences are. Obviously, if you're sending it to opposing counsel, that kind of footer would not be appropriate. Or if you're sending a letter to, say, a potential client, that kind of footer would not be appropriate. So it's good to think through, when do I need to use this and when don't I? And even to talk with your attorney about what the appropriate position would be on that. Okay, so now let's talk about the body of the letter. This is obviously the most important part. This is the reason that you're writing the letter. All these other aspects are really details. The body is going to be where you explain whatever the reason is that you're writing the letter. And we'll talk about some formatting things in a couple minutes about that. And finally, we'll have our closing. In the closing, we'll have some kind of closing statement. Very truly yours, or sincerely, or classics. I would stick to one or the other. Many firms have a particular preferred closing, and I encourage you to find out what that is. And if there isn't one in your law firm, I'd talk to the secretary of the attorney and say, how does he close or she close her letters? And then just take that example. If for whatever reason there isn't a tradition in the law firm, then I would recommend that you consider very truly yours or sincerely. Can't go wrong with either one of those. Other closings might be deemed to be too frilly or too informal, and you don't want your closing to be a moment of setting the wrong tone, setting a overly formal tone, and not that those are overly formal, but overly formal tone isn't going to hurt you. Setting an overly informal tone very possibly will. So we'll have our closing, and then we'll have our name, and then below our name we'll have our title. You need to include your title if you're on law firm stationery, because the assumption is anyone who signs a letter without a title below the name is representing himself or herself as an attorney. So you want to have your title. You can say paralegal to Mary Smith or Bob Green or whatever the attorney's name is, or you can just say paralegal. That's kind of your preference, and depending upon the style of the law firm. Many times as a paralegal, you will be working with more than one attorney, and so if you choose to have a paralegal to Mary Smith, just be sure you're keeping those straight, and so making sure that you're working on Mary Smith's client's work when you say a paralegal to Mary Smith, and when you're working on Bob Green's work, it's a paralegal to Bob Green. There's also some things that you might put at the bottom indicating that you have an enclosure, or the people that you are CCing or courtesy copying, as well as, of course, you wouldn't list this on the first page of the letter, but anyone that you might be blind courtesy copying. Let's go on to the next slide. Okay. Here we have some questions, some true false. A paralegal may not sign letters at work. This is false. Paralegals routinely do prepare and sign letters at work. Each law firm is different about this, though. Some law firms really prefer for the attorney to sign letters, so the paralegal may prepare them for the attorney's signature, but in most, or perhaps even all cases, the attorney actually signs it. Other law firms have a philosophy that paralegals can sign a lot of letters, but just be sure that you are in keeping with the culture and the preferences of the attorneys in the law firm. Second sentence, or second question. A paralegal may sign letters as long as he or she makes it clear that he or she is a paralegal. That is true. Obviously, the paralegal still can't include legal advice in a letter, no matter how she designates or he designates his or her position. So yes, the idea of signing a letter is fine, but the same rules that apply to any other communication with somebody still apply. The paralegal cannot give legal advice or do any of those other attorney-only functions. For example, the paralegal can't, in her own letter or his own letter, say, we want you to hire us as your attorney. That would not be appropriate, for example, because establishing the attorney-client relationship requires an attorney and a client, and a paralegal is neither one of those, so he or she cannot do that. Number 3, a legal letter is very similar to any well-written business letter. That is true. I mean, you can look up in any professional secretarial or correspondence book and find information about preparing business letters, and 95% of that is going to be very transferable to a legal letter. Number 4, while legal professionals are increasingly using electronic mail and instant messaging, legal professionals still mail a lot of letters. That is absolutely true. That is the preferred means of communication. Again, we've discussed in the electronic mail module the hazards and the challenges with respect to those types of communication. The letter is still the go-to way of communicating. And honestly, once you get used to formatting a letter, it really doesn't take much more time than it does to send a well-crafted electronic mail. After you send one letter to somebody, you can just open up that previous version, cut and paste and tweak it, and honestly, if you have a good format in place, it might just take you 5 more minutes to prepare a letter versus a well-written electronic mail message. Let's go to the next slide. Here's an example of a letter. You may recognize this. This is one that we have in our intro textbook. This is actually in the block format. We're gonna talk about this, and then I'm gonna show you this letter in a modified block format. So let's just look at the different parts so we can become familiar with it. The first part up here is the letterhead. So everything down to this email address would be printed on the paper. You can see that this letterhead is more than 1 inch, and it's not uncommon for you to have to drop your letter, the beginning point of your letter, to a point at which it's going to be under the letterhead. You wouldn't want to put, say, some of the content up here when it's actually in the letterhead. You wouldn't want to do that even if that particular spot in the letterhead is empty. You'd want to have it below that. And in fact, this is just below it. It's not wrong to do it that way, but I think most people would prefer a little bit more distance here. But you can see that's a pretty full letter, so I think that might have been the reason why they got it so close. So we'll need to have the date, and we do date the standard American way. We spell out the month. We have a space. We have the date. If it's a one-digit date, then we just put the one digit. We don't put a 0 in front of it. Obviously, if it's 2 digits, we put the 2 digits. We put a comma and space, and we write out the entire year. We'll talk about different places we might put it here. For a block format, everything is going, other than the letterhead, is going to be right here on this left margin. That's the characteristic of that. Block format is very popular in business correspondence. I think it's popular in part because it's so easy. You don't have to remember, well, which one do I indent here, which one do I put on the right margin, all that kind of stuff. It's somewhat less formal than a modified block format, and as a result, you'll find many law firms prefer the modified block format. You might find a law firm, though, that likes this format better, and as a result, then you may want to consider using this, or obviously you would want to use this in your law firm that uses this format. The key is to recognize there's lots of different ways of writing a letter, and as you go to work in different places over your career, you're going to see lots of different styles here. You may work with one law firm where the block format is preferred. Well, then that's obviously what you're going to use. The next law firm, they have a modified block format, and that's what you'll use there. It's good to be aware that there's differences in this area, and when you go to work at a place, it's good to ask some questions from day one, and also to ask for some examples so that you'll know how things are done in this particular place. Okay, the next item that we see here is the method of delivery. Here they have chosen to underscore it. They haven't italicized it. They haven't put it in bold. This is perfectly fine. It's pretty common to distinguish the method of delivery in some way, either by making it bold or italicizing it or underscoring it. You can see here that they have gone a little informal. They say via FedEx. Many people would prefer that you actually write out Federal Express or United Parcel Service or U.S. Mail or whatever the service might be. But this is also not outside of the things that you'll see from time to time. You can see they didn't include a tracking number. Again, that's a personal preference issue. You'll also see that they didn't put a space between the method of delivery and the address block. Again, I think that's because there's so much content in this letter. I think it's a better practice to put a little space here so that the method of delivery doesn't get confused with the inside address, which comes directly below this. Okay? The next thing is the address block. A couple of things that I think are not best practices here. One is that there was no a title put in front of Mr. Doyle's name here. We see down here the writer says Mr. Doyle. It's a best practice, though, to include a Mr. or Ms. or Doctor or whatever the correct term is in front of the name here. Why not do that is my point. You're not going to offend somebody by calling him Mr. John Francis Doyle Jr. And so there's really no reason not to do that. Let's talk a little bit about the titles that we can use. Of course, Mr. is pretty easy. If we're talking about somebody who is not a PhD or a dentist or a doctor or a member of the clergy, we're going to be using Mr. almost all the time, or a judge too. There's a judge or a clerk. We typically use honorable for that. But we'll use Mr. And we wouldn't write out the word Mr. We would just do capital M, lowercase r, and a period, a space, and then start the name. For women, it's a little trickier. Obviously, if she is a judge, we use honorable. If she's a PhD or a doctor, a medical doctor, or a dentist, we're going to use doctor. But if she doesn't have those titles, we have a choice to make. We might call her Miss, M-I-S-S, no periods with that. Or we might call her Mrs., capital M, lowercase r-s, period. Or we could call her Ms., capital M, lowercase s, period. In a business context, unless you know that this person has a different preference, you should use capital M, lowercase s, period. Many times you won't know the marital status of a person, or you won't know what their preferred term is. So M, lowercase s, period is preferred, definitely in those circumstances. But even if you know this person is married, you're going to use capital M, lowercase s, period, unless you have some reason to think that she prefers Mrs. or Ms. The vast majority of women are going to prefer MS, period, in a professional context. You may sometimes have clients who are maybe not interacting with you in a business sense. Maybe they want you're writing their wills, or you are handling their divorce, their child custody issue, and they may have a different preference in that area. And certainly if you're aware of their preference, then you ought to address them as is most appropriate. It's going to be relatively rare that you offend somebody with MS, period. Calling them Miss or Mrs., though, can be a minefield. And again, this is an opportunity to offend that you want to avoid. So you want to be as uncontroversial as possible. If you think somebody would prefer Miss or Mrs., it's very appropriate to ask them, which would you prefer? And again, that you wouldn't so much approach it in the sense of, well, how do you prefer that I address letters to you, but how do you prefer that I address you personally when you meet the person? You might even say, let's say you're meeting Mary Brown, and you say, "Hi, Mrs. Brown, it's a pleasure to meet you. Do you prefer Mrs. or Ms. or whatever the term is?" Good way to establish that from the very beginning. You'll notice after Mr. Doyle's name, we have Esquire. Esquire is a term that is sometimes used to refer to somebody who is an attorney. It's not perhaps the best way. Let me put it this way. It's a polite way of talking about somebody else, but it's probably not the best way of referring to oneself, or to, unless of course your attorney prefers it. It's just a skoonch gauche to refer to oneself as Esquire. And so most attorneys wouldn't, but one would perhaps refer to opposing counsel that way. Honestly, I wouldn't, unless I knew that he or she preferred that. It may be that Mr. Doyle has sent correspondence where he has used that, and so Mr. Gilmore is returning that particular preference that he's seen Mr. Doyle have in the past under those circumstances. So it's certainly something that can be done. I would not stick Esquire on my attorney's correspondence unless I know that he or she prefers that. Okay, then we see the address below. So you have the name of the person, then you have the firm that they're with, company or law firm, and then you have the address, the street address obviously, and then the city, state, and zip code. We'll have a little space here, and then we'll have the ray line. In this case, the author capitalized the R and the E. Sometimes people do it that way, but many times people just capitalize the R, lowercase e, and then put a colon here. And then they have the matter number. This is an effective way of describing the case. We can see that this letter is about this particular lawsuit, and Mr. Gilmore has included the case number, the court case number. So that's effective. But what Mr. Gilmore hasn't done is explain what the lawsuit, or excuse me, what the letter is about. Presumably it's not about every single aspect of the lawsuit. So I would say this isn't the most effective letter. The way that I would have preferred to write this is on my first line to say what the specific subject of this letter is, then below the second line put this information, identifying the matter and the case number. And again, you could have a third line that might say our case number, blah, 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 and possibly even your case number, blah, 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 blah. Okay, you probably don't want to put too much in one line. It's fine to have this much information, but even if this were a short piece of information, let's say that the style of the case was Harris v. Green, I wouldn't put the short summary of what this letter is about and the matter information on the same line. It looks cluttered, and there's really no reason to put those on the same line. So I would drop that down to the second line, even if there's space on the first line to continue it. And then if I do have a second line, I'm going to indent it so it's flush with my first line right here. Okay, again, we'll have a space here. Now we're ready for our salutation. Salutation is really easy. We're just going to say dear, and then we're going to say Mr. or Ms. or Dr., and then we're going to have the last name. We're not going to repeat the John, Francis. We're going to drop junior, senior, the third, whatever that is. So it's just Ms. Brown or Mr. Doyle, and we're going to have a colon here. A comma is for personal correspondence, and so you would never have personal correspondence on firm letterhead. If you're writing to your grandmother or something like that, then of course you can use a comma. You should put a comma. But if it's in a business context, if you're sending it, for example, from your business email, you'll use a colon every time. Let's imagine that you are writing to somebody and you aren't sure what the person's gender is. They have a name that you aren't familiar with, or it's a name that can be used both by men and women. Then it is appropriate to say, let's say instead of it being John, it was Pat. Dear Pat Doyle. So let's say all you knew was Pat Doyle. And obviously if you had Junior here, you would know it was a man, but Pat Doyle. Then you can absolutely write Dear Pat Doyle, or you can even say Dear Pat if you've met the person before. Obviously, if you've met the person before, you probably know their gender. But that's about the only time you want to list the first name and the last name in the salutation. There occasionally can be times where you might be more informal. Dear Bob, Dear Mary. I would be reluctant to do that though, because you're not going to offend people by being more formal, but you might offend somebody by being less formal. Now, there comes a time in a relationship where it becomes appropriate. It might even be a little bit weird to be too formal. But I would follow the lead of my attorney. And if he's still referring to people as Mr. or Ms. in letters, then that's how you ought to do it. If he or she begins using first names, then it's something for you to think about doing. Of course, some people are more comfortable being first named by the attorney versus the paralegal. Some people have a closer relationship with the attorney, and so it makes more sense for them to be on a first name basis. So it's something to consider in terms of the particular relationship. Err on the side of more formality, though, than less formality. Let's skip over the body of the letter for a second, and we're going to go down here to the closing. We can see in very truly yours is an example of an effective closing. Only the first letter is capitalized. So the V is capitalized, truly is not, yours is not, and we use a comma here. Okay? If you were doing sincerely, it'd be the same thing. Obviously, sincerely is one word, so sincerely, comma. Then we'll want to leave 3 to 4 spaces here for the signature area. Part of that's going to turn on how big the signer's signature is, but you pretty much always are going to want to have 3 spaces. The only time you might go down to 2 is if you're really trying to keep it on one page and you're struggling to have enough room for that. But I would say 2 can be used in that circumstance. Going down to 1, I would tend to say, go ahead and go into the second letter instead of doing that. Doesn't look as professional. And then we have the signatory's name, and you can see in this case the paralegal has prepared it for somebody else. So she's written his name, Alan P. Gilmore. And if you're preparing the letter for someone else, obviously you'll want to know how he or she prefers to have the letter signed. Many times people, even if he goes by Al, he may want his formal name in this letter. I'm sure he doesn't go by Alan P. Gilmore in everyday conversation. He may go by Al or just Alan, but he's going to want that whole name there. It's a kind of a more formal moment when you have this closing. He is also elected to have his title below here. It's not necessary though, because he's an attorney and this is on letterhead. So this isn't a requirement, but that's his preference. It's not wrong to have attorney below. Now, if Alan P. Gilmore were a paralegal, then it would be essential that he have his title here. But as an attorney, it can go either way. Now, obviously, you won't be signing the letter for Alan P. Gilmore, but just to prepare you for this, Alan may choose to write out his whole name, or he may choose to may just write Al. Or it may just be a squiggly mark. So many times the person will choose to have a more colloquial, friendly name that he actually signs below, and then below his more formal name. Perfectly fine. You're going to want to have at least one space here. You can see this letter writer actually has a couple of spaces here. I probably would have maybe given up a space here and given a space here if it were me, but different styles for different folks. This is important. These are typist initials. When you are preparing a letter for your own signature, for example, let's say Alan P. Gilmore had typed up this letter himself, you don't include this in here. But when somebody other than the person who signed the letter actually prepared the letter, and we're really talking about the typing, we're not talking about preparing the content. Presumably Alan, before he signs the letter, has blessed the content of the letter, so it's really become his from that perspective. But catching a typo or something like that is really what we're focusing on. And so this is kind of giving some accountability to the person who typed the letter. So what you do is you start, the first 2 or 3 initials are going to be caps, and they are going to be the initial of the person who actually signs the letter. So we can see A, P, G. Because Alan P. Gilmore chooses to use his middle initial, we're going to put his middle initial here. Then we're going to do a backslash, and then we're going to use the typist initials. They'll be lowercase. You can use 3 initials, or more commonly you'll see 2 initials. Again, the goal here is to identify the typist, and probably 2 initials are all that's required to identify this particular typist. We'll say she's Ellen Cummings, so that might be who that person might be. But if there's an Ellen and Edmund Cole in the office, it might make sense to use middle initials as well. Now we're ready for the CC section. Again, we're going to want to have a space. Well, one thing that we're missing here, by the way, is enclosures or attachments. The word enclosure, if it's singular, obviously would just be enclosure. If you have more than one enclosure, you're going to say enclosures. And then similarly, attachment or attachments. And sometimes those terms are abbreviated. Sometimes the attachments of the enclosures are described. Enclosures, colon, contract dated, blah, 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 date. The next line, certificate of service in blank case. So you can identify them, or you can just list them as enclosures. Technically, if you describe the fact that you have an enclosure in the body of the letter, you don't have to include it down here, but it's a best practice to do so. The reason that you're putting the signal in the letter is so that the person who opens it can immediately look down and go, oh, it says enclosures, but I don't see anything in the letter. And that alerts the recipient to know that he or she didn't get the full letter. And so now he can call Alan P. Gilmore and have whatever the attachment should have been sent to him so that he'll see whatever that document is. So it's a way to make sure that the letter is complete. So if you just mention it in the letter, it's not immediately obvious. And so a best practice would be to include enclosures or attachments down here. So let's go now to the CCs. Let's first of all talk about what a CC is, and we're going to contrast it to an ordinary recipient of a letter and also a BCC. Let's say that Mr. Gilmore wants to send this letter to Mr. Dole and Mr. Green. Well, if Mr. Dole and Mr. Green are both recipients of the letter, we would have one inside address for Mr. Dole, and then we'd have another inside address for Mr. Green. If Mr. Dole and Mr. Green work at the same place, we might just stack Mr. Dole here, then Mr. Green, and then list the address below that, as opposed to repeating it. But if they obviously have a separate address, we're going to have to list them both. That means, and so down here in our salutation, we're going to say, Dear Misters, and there's a different way of spelling. We don't just put an S at the end of Misters. Dear Misters Dole and Green, colon. So that's when the letter is addressed to both individuals. But sometimes we don't want to address a letter, but we still want to send a copy to some other individuals. Hey, we want you to know we sent this letter out. Some examples of people that we might want to do that with might be the client. Let's say we're sending this letter to opposing counsel, but we want to also let the client see what we're sending to opposing counsel. That can be one of our responsibilities as legal professionals, is to keep our client reasonably informed about the progress of the case. And this can be one way of doing so. So maybe Ms. Lindstrom is the client. Another possibility, or another person we might want to send it to, is we might want to CC our boss on the letter. Maybe Adams is the partner and Gilmore, actually Gilmore's on the letterhead, so it's probably not true, but let's assume for a second that Gilmore is the associate and Adams is the partner. Gilmore might want to CC Adams so that he can also see what's going on in the case. Those are two fairly common situations where you might have a CC. Now, I'm not, again, this has the same problem that we had up here with our inside address. We're not saying Mr. W. Danforth Adams Jr. Esquire and Ms. Charlotte Bayer Lindstrom. Better practice to put the Mr. or Mrs. in front of it. Oftentimes people like to alphabetize these names, or at least to group them in some, because you might have 20 people on this list at times. When there's just two, it's not a big deal, but if you have a lengthy list, you may want to consider alphabetizing it or organizing it in some way that makes sense. So something to consider. So there's another category. We talked about people who are actually going to get the letter, who the letter is going to be addressed to. Then the CCs, and then the last group is BCC. Let me pause for a second and talk about the term CC first. What does that mean? Why are we saying that? There's kind of two ideas about CC. One is that it's a courtesy copy. So as a courtesy to W. Danforth Adams and Charlotte, we are going to be sending them this copy. So that's what the CC supposedly stands for. Probably the more accurate historical reason that we call it a CC is it means carbon copy to these folks. Okay, a little bit of ancient history. Back in the day, well before my time, we didn't have photocopy machines. And so the way that a secretary would make copies of a letter is that she would put it in the typewriter, she would roll it around the platen, and she would have, in addition to the top page with the fancy letterhead and the nice paper, she would have a piece of carbon paper and then other sheets of paper. So it would be top page, carbon, another page, carbon, and all the way down. And you might have 10 of these layers. And so the carbon paper, when the key would hit the top copy of the paper, it would also cause the carbon paper to release the ink onto the page below. And so the top page would have a very clean ink picture of that particular letter. As you go down to the carbons, it gets more murky and more muddy looking. And so your last carbon is going to not look very good. I mean, it's going to be readable, but it's not going to have that crisp look about it that you'd want in a letter. Anyway, so the people who got the carbon copies were not the people that the letter was addressed to, but they were these individuals. And typically you'd keep one copy for the file, so that might be your final copy. So that's the background behind the term. We also have something called a BCC. The B in this stands for blind carbon copy. It's not referring to the handicap of the recipient by any means. It's not even referring to the handicap of anybody in this situation, but it is referring to the fact that Mr. Doyle and Mr. Adams and Miss Lindstrom are not going to see who the BCCs are. They're not going to know. Let's say you're sending this letter to Mabel Washington. Mabel Washington will see the front page of this letter. She'll see that the letter is addressed to Mr. Dole. She'll see that Mr. Adams got a copy. She'll see that Miss Lindstrom got a copy. But Mr. Dole will not see that Mabel Washington got a copy, nor will Mr. Adams, nor will Miss Lindstrom. To accomplish this, many times the typist will actually put this on a second page, maybe a page with no other writing on it, but ideally a page with no other writing, so you don't have to print up two copies of that page. And so therefore, if it's a two-page document, Mr. Doyle just gets the first page, Mr. Adams just gets the first page, Miss Lindstrom just gets the first page, Miss Washington gets the first page and the second page with her name on it. But you might send it to more than one BCC. Might be Mrs. Washington and Mrs. Lincoln. And again, it becomes a matter of office politics to decide whether you send it whether Mrs. Washington can know Mrs. Lincoln got it and Miss Lincoln can know Miss Washington got it. You might, in certain situations, need to have, 2 copies of that BCC, one with just Mrs. Washington's name and one with just Mrs. Lincoln's name, if you don't want the 2 to know about it. Now, you may be thinking, why would I ever want to do a BCC? They're not uncommon to do. They're not as common, though, as CCs, and certainly it may not be a common practice in your particular law firm. It's a discreet and diplomatic way of communicating information that you might want to make sure you're handling in a discreet way. Some attorneys prefer to put their client in the BCC so that opposing counsel doesn't know exactly what you've communicated to your client. There can be times where maybe another attorney is involved in the case, but you don't want to reveal that involvement of the attorney or some other person at this particular time. So you might have some strategic reasons. For example, you've hired an expert witness, but you haven't had the duty yet to disclose that information to opposing counsel. You want the expert witness to see whatever you're sending a opposing counsel, but you don't want the opposing counsel to know that you've hired this expert witness yet. There can be lots of reasons why you would do that, but it's a good option to have in your skill set. Some people choose to put the BCCs on the first page, and that's going to involve printing up the letter twice, once without the BCs, once with the BCCs. Whatever the preference in your law firm is obviously what you ought to follow. Now let's look at this same letter from the perspective of the modified block format, see what the differences are. Here we go. Apologize in advance for this because I don't have Word on this particular computer that I'm working on, so it's not as pretty a document as ordinarily we would have. So let's look at some features. Letterhead's not going to be changed. Instead of putting the date over here on this margin, I approximately centered it. It's not centered though. I tabbed it over until we got to the approximate center. It's not a best practice to center dates. This is probably the most common error that I have students make when I teach advanced legal documents preparation. They think that it's a best practice to center it, and I don't know how that idea developed, but it's not. It's not a good practice, and let me explain why. What you want is you want this J in June to line up horizontally with your V in Very, your A in Allen, and in this case your A in Attorney. If you center this, though, there's no chance it's going to line up perfectly with this because this has fewer letters than this. And so you're going to have to tab this over, and the odds that your tab is going to perfectly match is just really unlikely. And it's going to cause you a lot more work to even try to do that. So why not just tab it over to the approximate center? It's not important that you get to be the exact center. I have it right here. It could have been right here. It could have been right here. It could have been right here. There's lots of different places, but just to the approximate center. The important thing isn't that you be in the exact center. The important thing is that you line up with this. This looks sharp. When this is jagged, when this is here and this is here, that doesn't look good. And so that's the big takeaway from this. Then I put this on the left margin, sorry, the right margin. So instead of left justifying, which is the default position, that's this position right here, I have right justified it over here. I've chosen to put it in italics. Underlining isn't a bad thing. I think nowadays people see underlines, especially they're expecting it to be a link, but if you print out a letter, they're obviously not going to expect it to be a link. I'm underlining the case name here. We haven't gotten to Blue Book stuff yet, but I could have italicized this instead. I happen to prefer underlining for this particular function, and so I decided since I was underlining this, I was going to italicize this. Again, you're going to want to refer to your firm's style book if the firm has one, or to letters that your attorney has produced to see what the preference is. But certainly italicizing this or bolding this would be a common thing to do. I chose to write out the whole name of the company, but I didn't include the tracking number. Could have included it though. Now we have the inside address. You can see I put at least one space here. So there's a little bit of a differentiation between our zones. And we have the whole name. We have the law firm name, the address of the thing that we, of the law firm. Then we have a space, and now we have Ray. I've indented Ray. One tab. And then I indented again one tab to give us the style. I did not include a description of the case. That probably would have been a best practice. I'm again not working on words. I'm not sure how much change I can make. Here we go. I guess I can do some. So I might want to put I might say follow up regarding previous document request. And you're going to want to capitalize the latest word or the most important words with respect to this. So that's why I have some of the words capitalized. So now we have another space, and now we have Dear Mr. Dole, colon, and another space. You may recall when we were looking at this version that we had no indentation at the beginning of the paragraphs. That is block format. When we're working with modified block format, we're going to tab at the beginning of each paragraph. It's going to be the same tab that we use here with Ray. So you can see we're going to line this up. So we're going to kind of have some zones. We're going to have one tab, some things happening at the one tab point. We're going to have some things tabbing at the approximate middle point. Those are kind of our zones. And of course, we'll have some things on the left margin. Okay, now we're going to go down. We're going to again do very truly yours, comma, only the V capitalized. It's going to line up under the J. And we'll have 3 or 4 returns here. Then Alan P. Gilmore, attorney at law. That's optional. As I said before, you don't need to have that. I did it as just to be consistent. And again, apparently this attorney prefers that. I have the typist initials and I have the CCs. And again, I had the Mr. and Ms. at this point. Okay, so this is the formatting of the letter. This is the format that we use in advanced legal documents preparation. So if you've taken this course, I know that you'll complete your assignment this way. And I would ask that you also complete your assignment in this course in this format. Again, this course isn't primarily about format, but it's good to develop good habits at this point of being flexible and being able to adapt to different styles. Okay, so let's go on from here. Let's talk about the types of letters. By the way, I'm going to go back and talk about, sorry, here, I'm going to click out of this and go back here, unfortunately, because I don't have, let's actually go ahead and talk about the content of the letter since we're here. So let's read it. After reviewing the materials that you sent in response to my document request, I have concluded that you have not complied with the request. In my request, I sought, quote, all documents pertaining to the financial condition of Bente, Friedman, and Company during 2010, close quotes. You have responded by producing financial information for only 2 months of 2010. This response is unsatisfactory. Therefore, I ask again that you provide me with all documents pertaining to the financial condition of Bente, Friedman, and Company during 2010. Should you have any questions regarding this matter, please do not hesitate to call me. Okay, so we can see what the issue is. He's explaining what he sees a problem, and he's asking for a particular solution. This is an effectively written letter. He has more than one sentence in the first paragraph. He has he's written it professionally, politely, but I think firmly. And I think he successfully communicated his position. Each paragraph in a business letter must have at least 2 sentences. The only exception to that rule is the last paragraph in a letter. The last paragraph can have two sentences, but it doesn't have to have 2 sentences. Oftentimes the last paragraph is kind of a throwaway paragraph where you say, please contact me if you have any questions or something like that. And that's what this last paragraph is. I'm not saying it's not sincere, but it's a very common closing to a paragraph. And so that can be one sentence if that's your preference, but all the others need to have more than one sentence in it. So this gives you a flavor for how the tone and how you want to cite things. Obviously, Mr. Gilmore is not too happy with Mr. Doyle, but you know, he's communicating this in a professional manner. Okay, so let's now go to our next slide. So we're going to talk about 4 different types of business letters that you may be involved in the preparation of. The first one is an informative letter. That along with the second one are probably going to be the most common letters that you produce. Before we talk about, well, let's talk about informative letters first. This is your basically trying to inform, as just as the name suggests. Many times you'll be sending this letter to the client to update the client about what's happening in a particular matter. This a bill also would be covered in this type of communication. So the assignment that we have, for example, in this course is for a bill. That would fall into the category of informative letters. Oftentimes those will be to clients, but they can be to expert witnesses. They can even be to opposing counsel and other people that you may have the need to inform. The next thing is a confirmation letter. This is something that is very common, and I think when I introduce the concept, sometimes people think, wow, do you not ever trust anybody? And it really doesn't have that connotation. It sounds like we're very suspicious of other people, but it's become really just the tradition in the legal business, so people don't really see it as a lack of trustworthiness, more just a tradition that we maintain. But yeah, there is a level of just want to make sure that I'm protecting my client's interest to the utmost degree. Let me explain how it comes up. Let's say that you're calling opposing counsel trying to schedule a deposition. And you're going back and forth with dates. He's available on these dates. Your attorney's available on these dates. The court reporter is available on these dates. You finally work it out. It's going to be August 14th. And so you have confirmed that during the conversation. He's calendared it, you've calendared it, but you still want to send him a letter. Dear Mr. Green, thank you for talking with me today about scheduling the deposition of Janice Kirkpatrick. As you know, we were able to identify August 14th at 10 a.m. as a good time. And we'll be hosting that deposition in our offices, which are located at blah, 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 blah. If you have any questions or have some conflict has arisen, please contact me as soon as possible. Very truly yours, Cynthia Groover, paralegal. So we're sending that note because if somehow or another he wrote down August 15th and he doesn't show up, and then now there's a dispute. Well, did you say the 14th or did you say the 15th? He says you said the 15th. Maybe he's lying. Maybe he just was careless about the matter. But if you have a confirming letter, there really can't be a dispute about it. So it's very common to send those types of letters out. They're usually quite short. You want to be careful how you write them. You don't want to say, because I think you're going to lie and change the date on me, I'm going to memorialize this. It's more as a kind of a courtesy reminder is how you're going to phrase it, or making sure that we're on the same page on a particular issue. So that's a second type of letter. It's I guess you could say it's really a subset of the informative letter, but it's a particular purpose to just formalize what was said during a conversation. The next is an opinion letter. Let's save that one to last. Let's go forward and talk about demand letters. A demand letter sounds kind of nasty, doesn't it? It has a negative connotation with the name of it. And I guess it is kind of a nasty thing when you think about it a little bit more. But it's when it arises before you file a lawsuit. Let's say you have some dispute with somebody, and you've probably reached out to them, or maybe you haven't, since this is the first attempt to reach out, and they haven't been that amenable to settlement. Obviously, you're in this position of a potential plaintiff in this scenario. Well, you might choose to formalize your frustration, whatever the basis of your frustration might be, and put it in the letter. And you might explain the facts of the case and why you feel, or your client feels, that he or she is entitled to money or some other remedy. And oftentimes give that person a deadline. Please contact me by this date so we can explore settlement possibilities or something along those lines. And then oftentimes it includes either a veiled or a direct threat of litigation or some other consequence. There's kind of two categories of demand letters. One category of demand letter is one that is statutorily required. In order to file certain claims, you need to have sent this letter and you need to include certain specific information in it. Many times you actually have to mention the name of the statute, or you may have to give the person a certain amount of time before you can actually file the lawsuit after they have gotten the letter. So obviously if you are doing this to comply with the statute, you'll want to read the statute carefully to make sure you're dotting every I and crossing every T. But even in cases where it's not statutorily required, it's pretty common to send those because it can be a way of settling a case. Once you file a lawsuit, there's some expense associated with serving the lawsuit and proceeding with respect to that, expense for both parties. And so if it can be settled before the money, the costs start accruing, that's kind of a benefit to both sides. And so sometimes sending that letter can be advantageous. And that can be a reason to send it. A third reason to send a demand letter, it can be that it sometimes can be admissible into evidence in front of the jury. So whenever you're writing a demand letter, you ought to be thinking about how this will read in front of the jury. Are you coming across as a reasonable party? Are you describing the facts accurately? Or are you coming across as a jerk or a blowhard or a exaggerator? You want to make sure that your tone is respectful and professional and things along those lines. But you may also want to make the story clear and engaging for the jury. One more time for them to hear the facts in a light that's favorable to your client. So those are some things to think about as you are preparing the demand letter to write it in an effective way. It's very likely that the attorney will actually sign the demand letter because one of the purposes of the demand letter kind of is to intimidate the other side. And so having the attorney sign the letter suggests that maybe the same attorney will be the person who will be litigating the case. The person is already on board with this case. That attorney believes in the case and will be advancing the case. That's not always the case. I've got a lot of demand letters from attorneys. I didn't pay them off and I still didn't get a lawsuit from them. So it's not that you're necessarily sure they're going to file a lawsuit, but it's probably going to send a stronger message if the attorney actually sends the letter. Having said that, it's not legal advice because you're obviously sending it to the other side, so you wouldn't be giving the other side legal advice. So there's no violation of attorney, or it's not a prohibited activity for a paralegal to do. It just would be an unusual thing to go out under the paralegal signature, although the paralegal might routinely draft the demand letter in a particular law firm. Let's go to that fourth item, the opinion letter. The opinion letter does involve giving a legal opinion. So the attorney is going to definitely have to sign that letter. And the attorney is likely to be very involved in drafting the letter. That doesn't mean that you can't be involved in drafting portions of the letter, or you might even come up with the first draft of the letter. These are letters, these typically arise when the client has requested a written opinion about a subject. Maybe the client is considering a certain action and he wants written guidance from the attorney. And in part, oftentimes this happens because the client doesn't have very good options. And he wants, whatever option he chooses, there's some legal risk associated with it. And so he wants to have a written opinion so that whatever he chooses to do, he can point to the opinion and say, look, I tried to find the right answer. I paid this law firm to give me the right answer. And typically the client's going to say, I'm going to follow the advice of that letter. And yeah, there was no good path for me to take in the situations, but I had to choose between these and I chose this one. And so the hope is that the jury or the judge will look upon that and say, well, you were in a pickle. You didn't really have good choices, but you did the responsible things and we're going to give you credit for that. So that's how an opinion letter can come into existence. So you may have some involvement in that, but probably more limited. True or false? Legal business letters are always persuasive, and that would be false. The informative letter and the confirming letter are not persuasive. They're just objective legal writing. And of course, remember, we've talked about this before, but just a little reminder. Persuasive writing is not better than objective writing. Objective writing is not better than persuasive writing. There are times where objective writing is what you should do. There are times where persuasive writing is what you should do. But they're both important tools in the legal arsenal of a legal professional. Also, when you are writing persuasively, the rules about veracity, truthfulness of your writing do not get relaxed. You aren't allowed to bend the facts because you're writing persuasively. They have to be every bit as accurate as when you're writing objectively. So many times business letters will be persuasive. Certainly when you are writing the demand letter, you're attempting to persuade. When you write pleadings and when you file motions and file briefs and support motions, those can be persuasive. The opinion letter is more objective writing than persuasive writing. I suppose when you get to the section, you're likely to outline various courses of action that the client can take, and you'll do that objectively. But at the end, when you are coming to the portion where you're saying, and this is what we think you ought to do, you're going to talk about the pros and cons, but you might put a little bit of persuasive spin on it at that time. So definitely persuasive writing is part of legal letter writing, but it's not it's probably less common actually than objective writing. Let's look at the next one. It is important to know the purposes or goals of the letter before writing it. Obviously, that's kind of a no-brainer. If your goal is to persuade, then you're going to write in a different way. If your goal is to communicate information, you're going to write objectively. If your goal is to simply inform and confirm, then you're going to be looking at a much shorter letter than if you have a different goal. Many times you'll have more than one goal in the letter. This may be opposing counsel. Maybe you have had some tension with opposing counsel, but you know that your client ultimately wants to settle this case, and so you want to dissipate some of that tension. And so you might find yourself writing an especially friendly letter, even though the topic may not lend itself to being that friendly or whatever. But you may be looking for opportunities to build bridges and things along those lines. So you have to be thinking strategically about advancing your client's interest. Even if you think that law firm's a jerk, your opinion is really irrelevant because you're really advancing your client's perspective, not your own. When a legal professional wants to convey information to his or her client, it is usually best to call him or her directly. I wouldn't say there's really a true or false to this question. Part of it turns on the practices in your law firm. Part of this turns upon the particular client. I think probably the best practice is to call or arrange a meeting with the client, and then very likely to send a kind of a letter summary afterwards. That's kind of the best of both worlds. That involves time, and sometimes people don't have the luxury of that much time. And it can, some people getting that confirming letter are either offended by it. Well, why are you feeling like you have to document everything we say to each other? Or they're frustrated that they're having to pay for it or something like that. So there can be times where you don't want to send the confirming letter. But that doesn't mean that you don't, in some source, write down your summary that you may not send, but that you contemporaneously prepare. So if there's any dispute about it later on. Some clients like to get the letter. Some clients like to have the telephone conversation. Some clients like to get the letter so they can share it with another trusted friend or family member, and they can talk about it and have a little bit of opportunity to kind of take in the information. For many people, speaking with a legal professional is rather intimidating, especially about something that may involve really important issues in their lives. And so when they're talking with you, there's so much emotion happening there that it can be hard for them to hear all of the stuff you're trying to tell them. And so having a letter that they can read and then read again and then reading again can help them process it. So again, each client is different. If it's an individual, you may try to do the conversation in the letter. But if you are, say, corresponding with the legal department, is your client, so you're dealing with a paralegal or an attorney, so the situation is a less emotional one, then you might find that a letter is really what you want to do, or even a telephone conversation. So again, there's no set answer to this one. I'd say it depends is probably the best answer for that particular question. Hopefully this information has been helpful for you. We're going to look at a couple of other tools before we go forward. We already looked at this letter. This is an example. You'll find this in the folder, as you will the PowerPoint. And then I also have another document in here. This is about overbilling. We in the assignment we talk about, or the assignment that we have for this is a billing assignment. I think when we talk about ethics, it's so important to talk about the issue of billing time. Most of us in our careers as legal professionals will bill time. And when I say bill time, what I mean is that you will record the hours that you work, and those records will result in a client paying for your time. And as a legal professional, there can be a significant amount of pressure on you to bill a certain number of hours. Usually the pressure is significantly less on paralegals than it is on attorneys, especially partnership track attorneys. So that's the good news, but still there will be a billable expectation for many paralegals. When you bill your time, you want to make sure that your records are accurate. The best way to do that is to bill your time contemporaneously through the course of the day. So every time you touch a file, you take just a second, maybe you put it on a Post-it. Many firms use a electronic time recording system like TimeSlip that you can do very quickly throughout the course of the day. But if you do it on little Post-its or whatever, then you can go back at the end of the day and record that time. It's certainly a best practice not to leave the office that day until you've recorded your time for that day, especially if you were touching multiple files. If you're working on one file all day, perhaps you might decide to wait until the next morning to do that. It's very important that you have accurate records. If you overbill a client and that bill is sent by the mail, then you have engaged in mail fraud, very serious crime. People have gone to prison over that type of crime. You don't want to be that person. So be sure that your records are reasonable, that they're accurate, that they're completed in a contemporaneous way. Anyway, this is just a little bit of information. It's somewhat of a dated article, but it gives you some ideas about how overbilling can become an issue in law firms, and just some helpful things to keep in mind as we're exploring this particular topic. Hopefully this presentation has been helpful to you. If you have any questions, please bring them up in class. I thank you for your attention, and I'm going to go ahead and stop the sharing. Again, thank you for your attention.